Hello, everyone. Good time of the day, wherever you are. We're all in different time zones here. And I have the pleasure of introducing the speakers of this panel. Rather, I'll introduce the speakers in detail, one after the other, and we still have two speakers who are trying to get connected. So we have limited time, so I'm going to go straight to the presentations. The format is going to be conversational, so to speak. We have 4 presentations by excellent colleagues. You know them all. Even so, I will briefly introduce them. So I will start first with Jonathan Bonnitcha, who's going to be the first speaker. Jonathan is a senior lecturer at the University of New South Wales, and he's going to present. He's going to discuss his paper on the impact of investment treaties on domestic governance, a mixed method study, a paper that he co-authored with Zoe Williams, who is not with us today. So, Jonathan, your paper empirically examines the impact of investment treaties on domestic governance through cross-country quantitative analysis and a single detailed qualitative case study. How did you become interested in studying the investment treaties on domestic governance, and why do you think this is an important research?
Thanks, Katarina, and welcome everyone. So I guess partly it's just a question of background. So I see myself working broadly in a kind of legal realist or political economy tradition. And within that tradition, one thing that I'm quite interested in is not just what the law says, although that's important, but what the law actually does. So how law influences society. And against that background, I guess something that really struck me is our empirical assumptions about the way investment treaties affect domestic governance are in existing policy and legal debates about investment treaties. So in the claims of supporters and proponents of the treaties, you often hear these claims that they can have these really positive impacts on domestic governance, promoting the rule of law in developing countries. And in the arguments of critics, you also hear empirical claims about the impact that the treaties have in, let's say, discouraging public interest regulation through regulatory chill, things like that. So I was struck by the central role that these empirical assumptions play in existing debates. And then when I went and worked in Myanmar for several years in the investment agency there, working among other issues on investment treaties, it was just really struck me how detached the academic debate was from the reality on the ground of investment governance. Katarina, I think you're muted.
Thank you. Can you hear me now?
Yeah.
So thank you very much, Jonathan. And how about the state of empirical investigation supporting the assumptions about the effects of investment treaties on domestic governance? And where does your paper come into this? And what is the method you have used?
So I think we weren't the first people to grapple with this issue. I think generally I would say there's been more curiosity among critics of investment treaties around these questions than among investment treaty supporters. So in the arguments of investment treaty supporters, you sometimes see quite assumptions that investment treaties, just because they have fair and equitable treatment standards that reflect some conception of the rule of law, therefore they will have an effect on the rule of law in developing countries. So you see those assumptions at play in a very mechanical way without a lot of curiosity about whether that is actually the case on the ground or not. Among more critical scholars, though, I'm thinking of Mavluda Sadarova and Kyla Tianara, among others. Tom Ginsberg did some early quantitative work. There has been a bit more willingness to engage these issues empirically. Where I think our work sort of really joins on, that we combine quite a detailed quantitative approach. So looking at a data set that Zoe had from 1990 to 2016, so a very long time series data set of investment treaties and investment claims and a whole bunch of other variables, allows us to examine the relationship between investment treaties and metrics of domestic governance quality, and then also an exceptionally detailed case study in Myanmar, sort of based on my background knowledge working there, and then going back several years later with ethics approval to go and interview people and do a bunch of documentary work as well.
Thank you. So what are the results of your research? Do they confirm or do they disprove some of the key assumptions that are made in the existing literature? So for example, do investment treaties promote the rule of law or good governance domestically?
So if you look at the quantitative part of the paper, it sort of really takes the mechanical view that some supporters of investment treaties have on its own terms. Because if investment treaties did have a really positive, kind of quite mechanical impact on domestic governance quality, that's the sort of thing that you would expect to show up reasonably clearly in quantitative studies, especially one of the dependent variables we use. We run the study in a number of different specifications, but one of the specifications we uses the Worldwide Governance Indicator for the rule of law, which is actually very much based on issues that are relevant to investors like contract enforceability and property rights protection. So even taking those claims on their own terms, we find that investment treaties don't have a positive impact on domestic governance. But what's more interesting, I think, is the really rich qualitative case study. And so what comes out of that? I think that the headline finding is just that there is this really deep and sustained decoupling between investment treaties and processes of domestic governance in Myanmar. So even within the investment agency, where there is some real genuine knowledge of investment, the constraints of the treaties are not institutionalized across decision-making within the investment agency, and much less across government more broadly. There's no processes of legislative or regulatory review in place to vet new proposals for compliance with investment treaties, and there is complete and utter disconnection between the judicial system in Myanmar and investment treaties. So the judicial processes are just not seen as viable ways to resolve investment disputes, and there are no processes of connection that might, for example, involve training of judges or things like that in some way that would join up investment treaties to those governance processes.
Thank you. And one final question. What is the place of your research when seen against the wider debates about the different effects of international law, such as the debate about the extent to which international law affects private ordering outside formal dispute settlement?
Yeah, so there's a number of really interesting kind of wider findings. The first one I've already mentioned is this basic and profound decoupling between investment treaties and processes of domestic governance. And that will sort of resonate with those who are familiar with John Mayer's world society theory. That's not something we went out to look for. It was just quite a striking finding. The picture that emerges is really starkly at odds to rational unitary actor theories of the state. So these are no longer quite the flavour of the month in international politics in the way that they were 10 or 20 years ago. but then they nevertheless have this strange afterlife in international law, where lawyers sort of seem to think it's useful to work on the assumption that the state can be understood as a unitary actor. So that's obviously not borne out. But at a more granular level, it's quite interesting. We don't see the kind of acculturative and discursive processes at work that scholars in other traditions have seen. I'm thinking of Goodman and Jinks in international relations, but also scholars working in more critical or Foucauldian traditions. And interestingly, and this is where I'll end, we were quite surprised to find relatively limited support for some of the assumptions around regulatory chill. So it seems, and this is something that emerged really strongly from interviews across government and with foreign investors' lawyers, investment treaties are just not invoked regularly in relationships between foreign investors and bureaucrats. So the government is in contact all the time with foreign investors. There are all sorts of disputes and grievances being raised and resolved. And investment treaties are just not an important part of that story. So even with the quite comprehensive methodology we had, we were only able to pull out across many years 3 cases where investment treaties had even been invoked in relationships between foreign investors and the state. And one of these is particularly interesting, was an attempt by JTI, Japan Tobacco International, to discourage Myanmar from adopting new graphic health warnings on cigarettes. And what's so interesting about this is that Myanmar resisted that.
Thank you very much, Jonathan. We are over time. I hate to stop you.
That's fine. That was where I was stopping anyway.
Great. Thank you very much. I realize that there is a problem and people can't hear me. So I'm going to ask the questions. And if you could please repeat the questions, each one of you, to make sure that people hear them. And I don't know if I should do something like log out and come back in. So someone please tell me in the chat if I need to do something. So the next speakers are Maciej Zenkiewicz, who is research professor at Universidad Externado de Colombia and assistant lecturer at Nicolaus Copernicus University, and Gustavo Guarin Duque, who is PhD candidate at Saarland University, lecturer at Universidad Externado de Colombia, and trade counselor at the Mission of Colombia before the WTO. And their presentation is about the rights of local communities and international investment law. So first question for Maciej. In your paper, you have reviewed possibilities for local communities to defend their rights in case of alleged violations by foreign investors. You discuss the various available remedies before national courts, in investor state dispute settlement, an obligation of local participation, and so on. And I was wondering if you could introduce us to the topic by discussing the issue of local communities. And I note that you prefer the term local communities rather than, for example, indigenous populations.
Okay, thank you very much, Catherine. Should I repeat your question or may I proceed? Okay, so for those who were not able to hear Catherine, she asked me a very general question about our subject, which is local communities and investment law. So I will take those 4 or 5 minutes to introduce you to that subject and explain you why we pick up that theme. So first of all, this is absolutely ongoing research. We are not as advanced as Jonathan or Julian when I saw your papers. So of course, we are just searching for even questions, not maybe answers, because the subject is quite new. We are not claiming that we are the first one to notice that, obviously not. There are champions before us, like I know Nicolaus Perrone, Valentina Radi, vast literature is there, but it's still, comparing to other issues, rather neglected subject. So we think, so the starting point is that the idea of that research is to gather all the information regarding local communities, because they are reappearing from different fields, they are reappearing on the different levels, on the procedural, on the substance because of human rights, because of the substantive protection, what we tend to do is just take that massive amount of cases, information, guidelines all together, and to look or take one step back and look at that picture and to see maybe what the conclusion we can draw. So this is about the research. About the subject, because of time, there is no need to convince you that there is a problem with local communities. I will here refer just refer to all of the arguments which are presented mainly by Nicolaus Perrone for years right now, like 3-4 years, saying about the silent actor, about invisible actor, about the problem that they are absolutely left aside, that the system is simply not structured to take into account their voices. So therefore, this is bilateral, asymmetric system, state, investor, when unfortunately the investors, unfortunately the local communities are left aside with their problems if the state is not doing their job. And unfortunately, this is the case when the most problematic cases when the state is not fulfilling its obligation toward its nationals. It's working hand in hand with investors and sometimes even breaking the law hand in hand. So this is the problem which I hope everyone are familiar with. So our research, we are looking from various angles. We are looking at the main actors. So we, of course, we have 3 predominant parties here. So we have state, investor, and local communities. And the crucial role is, of course, of the state, because we can have the very diligent state who will contribute, who will take into account local community interest. And on the other side, we can have the state which will turn the blind eye on some minor misconduct or even violate hand-to-hand with the investors. So the role of state is crucial at that point, of course. Then we discuss the main rights affected. It's a little bit mess because we put all of those rights together. So of course we have some rights stemming directly from our system, investment law system. So expropriation, which is the most mostly invoked problem regarding local communities, almost the same like the FET and legitimate expectation. Of course, here we have the problems of human rights and environmental rights, which are not directly or not per se included sometimes in the BATs, that are stemming from interpretation or from systemic interpretation of the treaty or for the national law. So, of course, the human rights and environmental rights are extremely present and important with all of those disputes regarding local communities. And then we also put within that group, even if it's not precisely in that group, the violation of host state law. So all of the bunch of the law which forms the national law of the state, which may be violated by investors during his application for concession, for example. And within that big bunch of rights, national rights, we can have also all of those international obligations which states agree to incorporate into our own system. So this is how we identify all of the rights which are on the table regarding that dispute. And then, of course, we are moving to the not a bit very good term like the remedies, but all of the possibilities for local communities to appear and to fight for their rights. So, sorry,
right.
Catherine, are you?
Thank you very much, Maciej. There was a problem. There was a sound problem. I don't know if it was on my side or on your side. So I lost you for a moment. But thank you very much. So I will turn to Gustavo, and I would like to remind that we have to respect the time because we are over time. Everyone's taking a little longer. Just to say, I have logged out and logged in again. It would be great to know if the audience can hear me now. And also, this is something you can put in the chat, and you can also put questions in the chat. So, okay, thank you. I see. Okay, I will try to speak louder. Great, thank you. Okay, just to say very quickly that as soon as the speaker answers some first questions, we will open the possibility for everyone who's here to ask a question. So you will see this option a little later. In the meantime, if you have questions, you can also put them in the chat. We'll deal with the questions at the end. And so I will pass on to Gustavo. And the first question I have for Gustavo is, so in ISDS, the position of local communities is not procedurally the same as the position of states. So what are the tools available to local communities when it comes to ISDS?
Yeah, thank you, Catherine. May I repeat the question, so if the audience didn't understand? So in ISDS, the position of local communities is not procedurally the same as the position of states. What are the tools available to local communities in ISDS? Thank you, Catherine, for your questions. I really would like first to thank the SIEL organizers and the panelists and the audience for connecting with us today. It is an honor to be here, and this is a fantastic group of papers and speakers. Just going to the point, in reality, what the research have been shown is that tools made for local communities under ISDS arbitration are limited. We have a three-party participation or amigos curiae brief, but those are very limited tools for local communities. As my colleague Maciej has explained, procedural rights in the planning and execution of investment come as a tool also for local communities for before the ISDS. So I want to touch upon two particular points. First, tools made for local communities under ISDS arbitration are limited, and some international law may serve as partial relief. So we consider an option to enhance the domestic application of procedural standards in the light of international laws that extend from the protection of the indigenous communities' rights to the local communities as a group of people who needs to be protected because have been affected by the investment. So, for instance, we have under the protection of indigenous rights, the procedural right to free, prior, and informed consent, or the right of consultations for indigenous communities that may also apply in general to a broader scope of peoples. So we have seen how, in particular, governance in Latin America has enhanced a regulatory framework that address prior consultation and FPIC process with some degree of complexity. These countries in Latin America have adopted laws, and courts, constitutional courts, have adopted judgments that regulates the right in specific economic sectors and state decision making in a broader aspects with protective approach to local communities. So some countries provide for some rigorous methods for investment, other a laxer protection. So just to finish, for instance, in Colombia, a recent judgment from the Constitutional Court indicates, like in three essential cases, the right of FPIC is mandatory. So not only indigenous communities, but also in general local communities have the right to veto the investment procedures. So first, when it involves the transfer of displacement of the communities. Second, when they are related to the storage or dumping of waste. And third, when investment represent a high social, cultural, and environment impact on the community, which puts their existence in risk. So this preventive nature of international law enhanced by domestic governments will be a good approach to balance the ISDS before even the investment is conducted. Thank you, Catherine.
Thank you very much, Gustavo. I had actually another question about Colombia, but I think you have covered this already. So thank you very much. And let's move on to the next presentation, which is on policy exceptionalism. And it is co-authored by Julian Arato, who's professor of law at Brooklyn Law School, Kathleen Claussen, who's associate professor of law at the University of Miami, and Ben Heath, who's at Temple, who's professor of law, assistant professor at Temple University School of Law. So I start with a question for Kathleen. Your paper in international economic law, policy exceptionalism, what you call a policy exceptionalism. And so my question is, what do you mean exactly by this, and why is it important?
Okay, just checking the audio. Since I had all those tech problems, you can hear me. Great, thanks. Okay, thanks, Catherine. So what is this project about? This project raises concern that we have about this growing exceptions paradigm that we're seeing in international economic law. And by that, we mean a paradigm of justification according to which, first, deviations from primary rules are absolved by way of exceptions that may be express or implied. And second, in which claims of exception can be expected to proliferate. So we take the position that there's a need for a new paradigm of justification in international economic law, because exceptionalism, in our view, creates significant risks for the legitimacy and stability of the system. So two specific concerns within that paradigm. First is that reliance on exceptions reinforces the perception that states' trade and investment obligations normally forbid the kinds of measures taken in response to problems, for example, like the pandemic or other crises. So there's a misunderstanding or a perceived underflexibility of the existing primary rules. And the second concern about this reliance on exceptionalism is that this exceptions paradigm tends to expand the disciplinary reach of trade and investment adjudicators. So we have questions about whether international economic lawyers have the mandate or the expertise to decide difficult and often unresolved issues of things like, again, to use the pandemic, global health law, or other types of crisis situations that often come up and are the reason for the invocation for those exceptions. So we're concerned about the overreach that might develop. So given those risks, we are thinking about new paradigms apart from this exceptionalism one that could help us manage future crises and accommodate the values of IEL.
Thank you very much, Kathleen. So I turn to Julian. So you say in your paper that the over-reliance on exceptions in international economic law is leading to this policy exceptionalism, actually what Kathleen just described. But is the exceptions model really so prevalent? Many trade treaties have general exceptions clauses and security exceptions, but others do not. And most investment treaties do not, especially older investment treaties, do not follow this model. So what does that mean for your theory? And also, isn't the norm exception model fairly common? If it's so problematic, what explains its prevalence? What's the real harm here?
Yeah, can you guys hear me okay? Bad headset, but hopefully it's okay. Thanks. So thanks a lot for the questions. And so I think the crucial thing is to distinguish between what we might call formal exceptionalism, formal exceptions, and a sort of informal exceptions paradigm in international economic law. The former, it is what it is. Some treaties have explicit exceptions clauses, some don't. But what we're arguing is that the exceptions model has crept into not necessarily every aspect of international economic law, but a really shockingly large amount, especially the judicialized forms of international economic law, trade and investment, certainly. So what's the formal exceptions paradigm? It's you know, any trade lawyer, it's your bread and butter, right? It's the Article 20 of the GATT. There's of Article 21 also, there's a list of general exceptions, and there's the special national security exception. If you go against one of the main disciplines of the GATT and the World Trade Organization, non-discrimination, you discriminate or something, then you have a chance to justify your actions by appeal to a public health exception, an environment exception. And these are structured in very particular ways, right? Your action has to be the least restrictive means available to achieve a legitimate policy goal. Maybe or maybe not, there's some proportionality analysis involved. There's not supposed to be, but hey, it happens. So that's the normal sort of formal model. Now, most trade agreements have some kind of general exceptions clause. I don't want to say most, I haven't done an empirical study, but a lot of them do. And on the GATT model, at least for the sort of basic non-discrimination obligations. But there are plenty of trade treaties that don't have this. For example, even in the WTO, the more advanced technical regulations agreement, the TBT, the SPS on sanitary and phytosanitary measures, they don't have general exceptions clauses. TRIPS doesn't have general exceptions clauses. And certainly most investment treaties don't have these kinds of clauses. And yet we are finding that that exceptions way of thinking has come to permeate the resolution of disputes relating to all kinds of treaty standards, whether or not those norm exception dynamic is in there formally. It happened in the WTO in the context of the TBT. First, when there's explicitly a treaty in the WTO set of agreements that does not follow the GATT model, and yet all of that kind of GATT edifice of exceptionalism gets read into it. And even more subtly in the investment space, we find this sort of way of exceptions thinking that the norm is that you follow the discipline, and only if there's some exceptional excuse are you able to sort of get out of it. That has come to sort of characterize FET jurisprudence, expropriation jurisprudence. And a good example of this is the Philip Morris case, which technically rules on a public policy, police powers rationale, right? The tribunal says that Philip Morris, Uruguay's plain packaging legislation was okay on a police powers rationale, among other kind of many explanations in the case. And then yet they sort of make these comments like, but at the end of the day, health is special, health is exceptional, and that's sort of why we're coming down the way that we come down. So even though there's no general exception that's being applied, they just kind of find this mushy thing, police powers, and resolve the case by saying that there was no FET violation to even be justified. The way that they do that FET analysis is with this sort of exceptions paradigm in mind. And very, very quickly on the harm, yeah, these kinds of norm exception dynamics are common, but the harm here that we see is there's a bunch. One is that it subtly always puts respondents on the back foot. The assumption is that at the end of the day, what's normal is to follow the disciplines. And if you have a reason not to, you have to justify that. It might be a formal burden of proof, but even when there's not a formal burden of proof issue, it still puts a state on the back foot to have to explain its policy outcomes as exceptional to the otherwise normal disciplines. It also just kind of tends to lead to a heightening of the rhetoric on why policies are adopted. And we were thinking in the context of the pandemic, there's a sort of potential ratcheting effect that when you have public health issues, for example, it seemed clear to us that the pandemic is an obvious exceptional situation, right? An obvious situation where there's going to have to be some deviation from general disciplines in international economic law. But if that becomes the marquee example of an exceptional situation, what about other less emergency health situations? Does the bar kind of subtly raise even tobacco control, right? That's obviously incredibly important for public health, but compared to the COVID pandemic, if that becomes the poster child for a proper invocation of exceptions, there's a worry about goal shifting. I'm going to cut it off there, though.
Thank you very much, Julian. It's a very interesting. I find this topic very interesting. It's close to my heart because my PhD was on exceptions. Many things have changed since then, so I'm paying particular attention to what you're saying. So one last question for Ben this time. At the end of the day, exceptions in international economic law are designed to secure policy space. If your critique is right, are there viable alternative models to precisely do that, secure policy space?
Yes, I think so. So can everybody hear me? Good. Okay. So the question is, are there viable alternative models for securing policy space other than exceptions, which have sort of been, especially in investment law, dominant trend, and in trade a longstanding feature to secure policy space? I think the answer is yes. I'm going to give you 4 sort of buckets. I don't know if that covers the waterfront, but it's certainly 4. So the first bucket is interpretive roads not taken. So these were things that the treaty provisions could mean multiple things. We have gone down one path, we could go down another. For example, thinking about discrimination provisions in trade law, considering regulatory aims and effects, and not simply effects. That allows us to consider regulatory aims as part of analyzing a breach. It is an open-ended question about aims. It sort of is agnostic as to what public policies might be pursued. And so we're not in this world of, sort of listing a limited set of legitimate exceptions, but instead have a much wider, sort of looser array of policies that a government might pursue, and is more democratic in that way. The second bucket you might think of as things that can be done either through interpretation or amendment of treaties. And here an example is fair and equitable treatment. So, one thing that Julian maybe didn't have time to get into as deeply, but is useful to think about, is in the world of fair and equitable treatment, you have cases dealing with, for example, public health measures in the tobacco cases, where you have some suggestions by tribunals that public health is a special project and is therefore merits some deference or margin of appreciation or whatever word you might use. And that is the kind of soft or informal exceptionalism that Julian describes. It's not, no one's invoking an exception in a treaty, right? But it's like, oh, we all recognize that public health is special. But the problem, again, is that that's sort of canonizing a limited set of regulatory aims that you might find acceptable or appropriate for a government to pursue, which sort of sets at an international level what should be determined domestically, which is what do we want our government to be doing. So with fair and equitable treatment, another solution is to just roll back the really overreaching interpretations of fair and equitable treatment to a much smaller sort of world consistent with denial of justice, or sort of the more limited, outrageous, and shocking actions. Or at the treaty level, and I'm speaking for myself here, you could just delete this clause, guys. Come on. It's really, it causes way more trouble than it's worth, and it could simply be deleted. So that is a mechanism for securing policy space. Investment law would look very different without it. The third bucket are really heavily administered mechanisms for doing policy, like safeguards. Right? Not that the safeguards provisions in the WTO agreements really, work effectively, but the idea there is that you deviate through some kind of mechanism that is then administered procedurally, and that's embedded in the treaty framework rather than this sort of norm exception dynamic where there's not a lot of explanation about, when you fall inside the norm or inside the exception. And the fourth bucket are sort of more radical ways of thinking, which is upending the entire, upending our entire way of thinking about the system. And this is sort of where I'm trying to think further. And so my ideas are a little more inchoate. But for example, Michael Thackeray, who's now the special rapporteur on the right to food, has a paper from last year pointing out that 85% of food globally is consumed locally. And if we were to consider local consumption the norm, and liberalized movement of food to be the exception, right? We might start to have a different trade policy around agriculture that that ensures first and foremost that food produced can be eaten by the people where it is produced, and then surplus is redistributed to help other people around the world live a full and nutritious life, right? And so their trade policy looks very different from the way it looks now, where liberalization is the norm and keeping food, invoking food security to make sure food does not leave your country is the exception. So those are sort of four ways of thinking about preserving policy space that are maybe different from our current paradigm. So I'll stop there. Thank you.
Thank you very much, Ben. Just one thought that. Can you hear me now?
I think it's lag. I don't think it's the mic.
And then you. Sorry, can you hear me? Yes. Okay, good. Okay, I'll just go quickly again. So it's just a comment on, you can exclude that standard instead of introducing an exception. The difference is that if you exclude one standard, then you're not giving obviously investors a particular protection. While if you introduce the exception, you still give the protection, but you allow the state in some cases to not respect the standard of the protection because you have introduced an exception. So if one takes this reasoning to the extreme, one might say that would better not sign investment treaties because then states would have maximum policy space. So I'm doing the devil's advocate here, but maybe something for the discussion if we have time. I'm just raising it. And now we move to the last speaker, Zhenyu Zoe Xiao, who's a final year PhD candidate in law at the University of New South Wales, like Jonathan, at the University of New South Wales. And her research focuses on international investment law, the political economy of China, and their interactions. And so she has written a paper on international law and domestic institutions, rethinking the evolution of China's ISDS policymaking. So, Zoe, in your paper, you examine a crucial turning point in the evolution of China's investor-state dispute settlement policymaking. Would you like to tell us a bit more about it?
Catherine, I hope everybody can hear me. Yeah, thanks. So as many of you may know, China's engagement with investor-state arbitration has followed a very distinctive trajectory. So its first investment treaties adopted a very restrictive stance on investor-state arbitration. Then from the late, it suddenly expanded access to investor-state arbitration while integrating domestic administrative review procedures. And since then, China has become a relatively strong proponent of the regime, despite some fundamental backlash against investment treaty arbitration around the world. So I would treat the treaty policy change in the late 1990s as the crucial turning point in the evolution of China's investment treaty arbitration policy change. And my whole paper is driven by this question: why did China expand access to investor-state arbitration in that particular way in the late 1990s? Yeah, thank you.
Thank you. So what are, in your opinion, the inadequacies of existing scholarship? For example, you say that existing scholarship appears to view China as a unitary actor. What do you mean by this? Can you tell us a bit more about it?
Yeah, I'll answer this by providing a brief description of existing scholarship. So according to the most regularly cited explanations for China's treaty policy change, they attribute this change to the protection of emerging outward Chinese investments or the encouragement of inward foreign investments into China in the late 1990s. So such explanations operate largely on the international plane, and they rest upon an assumption that the Chinese state can be understood as a unitary actor in pursuit of its economic interests. While I agree that they represent a crucial first step in understanding the treaty policy change, I would see they have like three common inadequacies. The first is that their search for the reasons stops at a particular time point or at a single event instead of tracing the whole policymaking process. And the second is that they tend to view the policy change in investment treaties separately from China's domestic shifts in ISDS mechanisms, such as few of the existing scholarship have explained why China integrated domestic administrative review procedures with international arbitration. And the third inadequacy, I would say that existing scholarship tends to disregard the effect of domestic politics on the treaty policy change. And that's why I argue that the Chinese state should not be understood as a unitary state. In understanding the policy change, because we need to pay special attention to the role of local governments in China and the particular dynamics of China's internal central-local relations. Yeah, and because my paper captures only a component of my PhD thesis, so it mainly addresses the first inadequacy by empirically investigating the policymaking process prior to the treaty policy change in the late 1990s. Yeah.
Thank you very much, Zoe. And so what do you think triggered China's treaty policy in the 1990s?
So as mentioned earlier, I agree with existing scholarship that the protection of emerging outward Chinese investments and the encouragement of inward foreign investments into China were important in driving the policy change in the late 1990s. But further to that, what I have found in my empirical investigation of the policymaking process is that this treaty policy change is not a single, all of a sudden event. It emerged from a longer incremental process of policymakers' reflection about China's engagement with investor-state arbitration. So I would say in their reflection process, the Chinese policymakers understood that the main risk of investor-state disputes in China mainly came out of local governments' particular types of interactions with foreign investors, and that China was able to rely on domestic administrative review procedures for investor-state dispute prevention, dispute management, and also for the regulatory control over local governments.
Thank you. And one final question. What can you tell us about investment governance and internal policymaking processes in China as these have emerged in your research?
Yeah, I want to begin by pointing out a key domestic actor in this policymaking process, that is Chinese Ministry of Foreign Trade and Economic Cooperation, for short, MOFTEC. It was the former Ministry of Commerce, MOFCOM, which was responsible for developing the treaties, laws, and policies in relation to investment in China. So my paper draws on an extensive search of primary MOFTEC policy documents, research papers, and also personal papers from MOFTEC officials between the late 1980s and the early 2000s. I've also relied on interviews with former MOFTEC officials and academics directly or indirectly exposed to the policymaking process. So my main findings are that being a party to the XXIII Convention started China's MOFTEC's internal process of thinking about the possibility of further engagement with investor-state arbitration and how to manage the risks of such further engagement in the early 1990s. And in this process, MOFTEC policymakers also gained a clearer understanding that the main source of investor-state disputes in China is from local governments' particular types of interactions with foreign investors. So the MOFTEC policymakers had two main considerations in further engagement with investor-state arbitration. One of them is dispute prevention and dispute management, and there is also a collateral benefit of exercising regulatory control over local governments. At that time, they intended the integration of domestic administrative review procedures to achieve both objectives. So this whole reflection process provided the pathway for MOVTech policymakers to feeling more comfortable with granting a wider access to investor-state arbitration in investment treaties in the late 1990s. That's what we finally see in the treaties. Yeah, thank you.
Thank you very much, Zoe. Thank you very much, everyone. And now we have some time for discussion. And we have some time, I hope, for some of you to be able to address some issues that maybe you haven't had the time to address. So I have opened the Q&A function. So if someone would like to, if someone from the audience would like to take the floor, please request the floor. Actually, I'm not entirely sure how you see it on your side, so I can't tell you how. I hope it's obvious. So I just know that the function is enabled, and there is a very interesting discussion going on in the chat. I don't know if someone would like to, I haven't identified any questions in the chat. I know that some speakers have been answering questions or have been engaging in a discussion. So would someone of the speakers first have a question for another speaker? Or would one of the speakers like to take the floor to add something or to comment on some of the discussion that has been going on in the chat? So it's difficult. I don't think necessarily people can follow both.
I just make a suggestion while people are thinking about it, and then
Please.
I can just say some words to kill a moment of time. So maybe at this point we should go off the chat so that we're not all monitoring the chat and the discussion, since we have time for people to raise questions. And just to briefly respond to one from Wojciech Giezma, if I'm pronouncing that right, Giemza. So he made an interesting point about the Argentina cases in the context of exceptionalism, where there are everyone sort of says, of course, Argentina in the case of a true emergency should be able to take measures, but there's always questions of exactly like how far those measures went. Did you go too far? And the devil is in the details. And I just wanted to add to that. I mean, absolutely, we all, I think, agree with that you can say all you want about the right to regulate, the right to deal with an emergency. This responds a little bit to Mona also, but the devil is going to be in the details. But I also would just add, speaking for myself only, that there's real north-south concerns there too, right? I mean, what states get trust when they take a COVID measure that they really took the least restrictive means, right? Least restrictive means sounds so objective, but it's so discretionary. Who gets the trust that they really took the least restrictive means reasonably available? I'm not meaning to impugn any particular arbitrator or anything like that. I think these things are just really complicated, but there's all sorts of cognitive biases and subtle biases that go into questions of how much you defer to the assertion by a state that their actions were reasonable. And I think the exceptions paradigm is what puts us in the position of thinking this way. It's not the only thing that does it, but it really intensifies some of these. Some states deserve trust when they claim an exception, but maybe others less so. Again, someone's going to say, of course, northern states like Canada gets hit all the time for their policy measures. I'm not trying to make a very broad-based statement here, but yeah.
Thank you, Julian. Ben, please have the floor, and then I have a question for Maciej.
So if I can just jump in on that and maybe connect it to the discussion of local communities we were having earlier, because I think there's an interesting sort of connection there. So take Bear Creek, for example, and just sort of stylize the facts, because if we get too deeply in the weeds of facts, we can always find a reason why the case should have come out exactly like it did. But Bear Creek speaks to a dynamic that I would imagine is quite common. across the world, but maybe particularly in the third world, which is that, you know, at time one, an investor was entering the country and engaged in consultations with indigenous communities and local communities and so forth. And in many times, if I remember the facts correctly, brought the local officials with them to do that. Local officials sort of ratified the way they were going about it by their presence and their behavior. And then at time two, there was resistance from local communities, some of whom felt they weren't sufficiently consulted or weren't sufficiently sort of integrated into the process, whose interests weren't taken into account. The pushback didn't take the form of sort of reasoned deliberation. It was often violent. There was property damage. There were incursions onto the property of the investors. There were massive protests. At one point, the border between Peru and Bolivia was shut down for several days. You know, so the problem was combative and heightened, and then you see the government switch its position, right? And eventually the investment is shut down, and the investor loses a great deal of money, right? Or claims to. So at that point, how do we deal with this as a reason or fact kind of situation? How is this policy based on reason? This looks like policy based on pure politics. At the same time, this is a state being very, very responsive to resistance from local communities in a way that we might actually want a government to be responsive to. When people march in the streets and things get broken and windows get smashed, we maybe want government to change what it's doing, right? And investment law has a real hard time accepting that, right? Accepting that, you know, if someone sets fire to a police car, that actually might mean the government should change its policy, even if the same officials are in place, and even if people, you know, can't really, haven't really gotten behind the alternative paradigm being suggested by the protesters. And so creating flexibility through other reasons than demanding strict proportionality and necessity and least restrictive means may be the best way to enable that flexibility in the world that we might be heading toward, where that happens not just in the United States and elsewhere. So that's thinking for myself, but connecting these two things and sort of thinking down the lines where I'm going with this project in my own work. So thank you for all that.
Thank you, Ben. I think Maciej would like to make a comment about the difference about local communities and indigenous populations.
Hello. Yes, indeed, and also I will refer a little bit what Benton already said. So, first of all, just for a clarification, we prefer to use local communities, even if it's easier to take advantage of the normative landscape which we have regarding indigenous communities. But the problem is that if we want to search, as I said, that our research is quite broad, for the solution for the future, we should not restrain ourselves only to indigenous people, because in that moment we are falling into the trap that maybe we are looking for the solution for just part of the society which are affected, because then there will be the societies which are affected, which will not be classified as indigenous people. We know there is a big struggle, and we can mention many examples when the community needs protection because it's vulnerable, it's in the extractive zone, but it's not indigenous in the sense of the hardcore definition. Or maybe it's like in Colombia there is a difference between indigenous people and ethnical community, for example. So once again, we don't want to enter that dispute. We don't want to give another problematic choice for arbitral tribunal, which are designed to resolve dispute of investment, but right now they are deciding on environmental law, on human rights, and right now they will be deciding who is indigenous or not. So simply just for the sake of the dispute, even if we are losing a little bit because we are not using that normative force of ILO convention and all of the legislation which we have regarding indigenous people, we think that the solution should be towards local communities in general, not indigenous people in particular. And also here what Benton said, that I don't think that the system is designed to resolve that problem. The system of the investment law simply has no solution. So amicus curiae is just, it's just some backdoors which is not working. The third parties participation doesn't work. So what we are seeing, that we have the vast majority. What I would like to make reference to the John Ruggie vast contribution regarding multinational corporations, and I see a little bit this alike, because what we should look like here with the local communities is to put emphasis on all actors, and it should be emphasis on the state to enforce national law. But then in the case of that, I'm not saying 5%, 10% of those extractive industries, third or like South America countries, when there is a problem of transparency of the due diligence, etc., etc. So in this moment, the obligation on state could be, I'm not saying replaced, but complement with the obligation of company, of the investors, to take that due diligence, to not bluntly believe in the words of state, or even like in the Beer Creek and the others, they were doing as little as they could, because if the state allow us to just do in the formalistic way the consultations, let's do it. But then we see that there is a struggle, there is a clash with the local communities. So we are talking about the company. Yeah, so go ahead.
Sorry to cut you, Maciej. I just see we have some questions, so if you don't mind,
Yeah,
I'll stop you. Thank you. Joshua, you have the floor.
Thanks. Can you hear me? Yep. Yes. Sorry, just thanks for a really interesting panel. Just a quick question directed at Julian, Ben, and Kathleen. So obviously we've kind of all read your piece in Agile. I haven't seen obviously the paper you submitted to this conference. I was just wondering if one of you wouldn't mind expanding a bit more on, I guess, how you're defining or operationalizing the difference between, I guess, flexibilities within the content of the primary norm and either kind of exceptions or carve-outs or reservations and non-conforming measures. I sort of understood the way, I guess, Julian was explaining that, you have a problem with TBT 2.1, so it's a flexibility in the primary rule, but then they've kind of read in all of the de facto exceptionalism. But I guess I was just kind of trying to map out in my own head and a bit unsure about how you actually draw that line. I'm thinking, for example, of, say, national treatment in the investment context, where the justification stage, you kind of, it's necessary to engage with it to show that there's been a breach. Or in the expropriation context, there are some tribunals like the El Paso Tribunal that have just said bona fide regulatory measures are generally not expropriation. So I was just wondering if one of you could explain on, I guess, the difference between that flexibility and justification within the content of the primary norm versus exceptionalism that you want to get away from.
Thank you. Before giving the floor to the speakers, please bear in mind the time. Also, this is for future questions. So please go ahead.
Julian, do you want to take this, or?
Sure. We were negotiating on context. Yeah, so just a very quick version of this. This is obviously going to be a very long section of our paper, so I'm not going to give the full story, but thank you, Josh. I think it's a really critical question. And I think the way that I would frame it is, it's not going to be a clean line drawing thing, but it's a dispositional thing. So with national treatment in an investment treaty chapter, let's just say all it says is like copy paste from the GATT style national treatment. There's a million different ways these things are drafted, and there's no exceptions clause. And so we would suggest that the way to interpret that is that there is flexibility in the primary norm, right? Which is to say, if you did not have a discriminatory aim, no matter what the disparate impact is, you have not discriminated, right? So someone is going to have to show that there was an aim. Someone is going to have to show that it was a good aim. And there's going to have to be tests for that. And those tests might look a whole lot like proportionality step 1 and 2, right? Reasonableness, legitimate aim. Sorry, and then least restrictive means. It could be that, it could be another test. And so at the end of the day, all of the sort of tests and the steps might look very similar to what you see in Article 20 of the GATT, but it doesn't lead to the same problem necessarily if the whole framing of it is that you haven't discriminated until you've actually done something for the wrong aim, right? It's not that you have certain exceptional justifications, which if it's an exceptional situation, you can justify having deviated. It's that there never was a discrimination here. And that has a lot of subtle knock-on effects for the disposition of a case, we think. But these, in terms of the actual tests that get applied, I wouldn't necessarily draw bright line rules. It's a sort of dispositional thing, and when it comes to litigation, it's a very important rhetorical thing, which has, I think, important effects for who's on the back foot in litigation. But we could go on a lot. It's a great question and just a very hard one. So thank you, Josh.
I don't think we're hearing Catherine.
I'm seeing the Catherine. Yeah.
So let's call on Gustavo.
Yeah, thank you. Can you listen to me or? Oh, good. So, no, in general, well, a comment is that the point with exceptionalism is that actually touches with legal certainty at the end. So basically that alike cases are treated in the same way. So in this regard, I just have this question, especially with this concept of local communities again. Because maybe the concept of local communities makes sense looking from the Colombian perspective, when the concept is really defined. But I'm thinking on a global perspective, will enhancing this concept of local communities in a broad sense will not create a narrative to further fragmentate the regime. So just to give you an example, if you take the same concept of local communities, and you take it for instance to the Russian Federation, when you can take I don't know, the state of Dagestan, and then you can have so much particularity inside of the same state of the Russian Federation. So suddenly, if you want to defragment or you want to further fragmentate the regime intentionally, you can actually use this narrative on local communities to actually have different type of arguments in a specific case. So from the systemic point of view, how we can prevent to expand this concept of local communities to a point that it can further fragmentate the regime and obviously debilitating the international rule of law. And thank you to all for your very good panel.
Okay, if I may, so I don't think it's big danger to fragment and to create the new thing which will endanger the system. Because what we are asking for is not something new. What we are asking for is that we will apply the same standard if the investor is building something in Germany or in France, or he's doing that in the remote, distant region in Colombia, for example. So we are not. We do not want to create a special category of local communities. What we want to say is that simply, if national law works and if the institutions are fine enough, they're working like it was in the Canadian case in the Bitcoin, for example. So it may be the solution. Okay, so we are not saying that it has to be something new. So what we are thinking right now, but once again, I will go back to my very first sentence. So this is ongoing research, and we are making those tentative conclusions just for that conference to be crushed, criticized, etc., and push forward our research. That simply, we don't want to create a new category. Local communities, they exist on every level, in every country. And in most of the countries, they are properly addressed. If in Europe we have the environmental affecting society investment, for sure the local community will be properly addressed and asked, and they have chance to react. The problem is, of course, in those remote regions. So I do not agree. Okay, I'm taking that as a critique of Gustavo. I don't think that's a problem. Okay, and I will be brief and I stop right now. I don't know if someone else wants to add.
Yeah, Thanks for the rigor in self-enforcing time limits. Because we've lost Katharina, I'll take over asking some of the questions for the time being. So if people in the audience want to type things into the Q&A, please do. I don't think we've got any outstanding questions there at the moment. But Zoe, my question for you is, so you told us a kind of institutional story about the development of Chinese policy relating to investor-state arbitration. And one thing that was important in your story was the goal of controlling local administrative action, local authorities who were interfering with investment projects. Did you find out if were those institutional arrangements successful in achieving their aim?
Thanks, Jonathan, for the question. Can you hear me? Okay, yeah. I have got conflicting evidence from different generations of MOFCOM officials to show whether administrative review or investor-state arbitration is effective in controlling the local authorities. But in my view, and if I combine it with the evidence I have got, I would say they're not so effective in controlling the local authorities, because it's even not used by foreign investors in resolving the disputes with the Chinese government.
Interesting. What about do we have any more questions from the audience? All of a sudden, after a very vigorous chat during the actual presentations, when we were all frantically trying to concentrate, things seem to have gone very quiet. So now is your chance in the audience to ask one of the questions that you were hammering into the chat in person.
There's another question for Zoe on the intellectual inspirations for Chinese model bits.
Thanks. Can I answer now? Yeah. Okay. Generally, I would say the intellectual inspirations for Chinese model bits, we can see a change from the European model to the more American model. But I think China has its own policy choice towards the key provisions, such as the investor-state dispute settlement provision and the national treatment provision. So they can go with the European or American model if the provisions are not so important. So they can just follow others. But if that concerns China's own sovereignty or very important matters, it will have its own choice. Hope I have answered your question.
I see, Kathleen, you may have seen there's a question in the chat for you from my colleague, Wei-Huan. Did you want to take that? He asked, Julian was talking about a purely aims-based approach, but isn't it true that effect is part of an objectively aimed test or an objective aims test?
Before, hello, thank you so much, Jonathan, for taking over. I apologize to everyone, my system froze, my computer froze. So I would just like to remind everyone that we are running out of time. So could we please make this the last question?
I'll pass that to Ben. I'm sorry, I'm not seeing that one. I must. Yeah. So thank you. I mean, yes, effects would be part of it. We'd be talking about an aims and effects test, right? But that's at least in our preliminary thinking, that still makes the test qualitatively different from a simple focus on effects.
right? Recently, a quote from Barry Appleton surfaced from sort of the early days of investment law, where we were trying to decide whether we were going to follow the WTO model on MFN, where Barry argued that, look, if in the first instance the United States banned a poisonous chemical, but it did harm to investors, it was a disparate impact, that's an MFN problem, right? Investment law hasn't quite gone that route. From the national treatment side, there's a good paper by Nicholas Damasio and Joost Pauwelen about why in the American Journal of International Law. But in trade, they're still sort of dealing with the fact that you can breach the primary norm sort of largely on the basis of the effects of a measure, and regulatory aims are then taken into account at the back end. Whereas taking things into account at the front end would produce a very different kind of analysis, even if effects were still sort of one factor floating around in the hopper.
Thank you very much, Ben. Thank you very much, everyone. Thank you very much, everyone, all of the speakers for being here. All of the people in the audience for being with us, for asking questions and engaging actively. I apologize again for popping in and out of this session. That was due to technical problems. I wish everyone a nice continuation of the conference. So with that, the session is closed. Thank you very much, everyone.
Cheers.
Thank you.